Welcome back. Happy Money Monday. I swear to you, Mondays come around super fast. But happy to be back. Happy to be here to talk to you about Money Mondays. For those of you that are new, I'm Jayla. I am here as a helpful guide on your journey to build and protect your wealth. And this is your time to ask questions, to learn something new, hopefully, and just see a friendly face during quarantine. So I hope you guys are all doing well. And welcome to Money Mondays. All right, today we are talking about what happens if you die without a will. Topic I really didn't want to talk about, but I've seen so many people this year that have left this earth, this life, without their plan in place. So I know I had to talk about it. So I want you to understand that this conversation is going to come from the perspective of California laws. So if you are not in California, you will need to go to your state's probate code because it could be different, might be different than what you're hearing here. But in California, when you die without a will, it's called intestate succession. And that's a term I want you to know. Keep in your back pocket just in case. Because it's just a big word for they didn't have a plan. So when somebody dies intestate, it means they don't have a will. If you die testate, it means you do have a will. Terms. But to kind of talk about this and ask any questions, if you have any, welcome to all those who are still joining. I'm going to use an actual example, a real life example, somebody that I know that passed away without a plan, and hopefully that'll help you understand the process and what happens and what to expect when you have to deal, or your family has to deal with probate court. So the person that I knew that passed away without a will, I think she had just retired maybe 3 to 4 years ago. It was actually a situation where she really needed a plan. She didn't have an advance directive, so her family ended up keeping her on life support for a while, and they weren't sure if she was okay with that, if she was a DNR, do not resuscitate, or if she wanted to receive life-extending care. So that was another issue. They let her go, and after they let her go, because there was no will, she doesn't have any kids, she didn't have a spouse, so without a plan, they're going to probate court, of course. She did have a niece that she had been taking care of for decades, that lived with her, lived in her house, and some of the life insurance she had, she put her as beneficiary. There was evidence to show that she wanted to take care of this niece. But like I said, she didn't have a spouse. She did not have a child. And the only other person that she had outside of the niece was the brother. So if she has a house, who gets the assets? Who gets what she had when she passed away? Now remember, she's taking care of and saying that she wants her niece to get everything. Anybody got the answer? Put it in the chat. I hate saying it, but I know you guys know. Despite what she may have wanted and the fact that she had been taking care of her niece for decades, they had lived together, her niece was paying the mortgage on the house, brother gets everything. Brother is the next of kin. Let me let y'all see if I can let you see the chart, because I'm visual. It kind of helps me to see things. Hopefully you can see this chart, and it'll help you understand when we're going through these things, who gets what. So when I told you, we're starting at the person, the first row. When I told you that she didn't have any children, which meant she doesn't have any grandchildren, no great-grand, you have to go back up. So does she have any parents? No, she doesn't have any parents. They're all passed away. So now we're at the brothers and sisters, and that's where we stop. The minute we find somebody alive in a generation, that's who gets the assets. So let me pose this question and kind of change our example. And for everybody just joining, we are talking about what happens when you pass away without a will. I'm using a real life experience about someone I wasn't able to help because you guys know I refuse to do probate. So when people come to me, I have to refer them out because I want to save you from probate because it hurts my heart. It's devastating. Especially in that case where you saw she wants to take care of her niece. She just didn't have the plan. So now the niece doesn't get anything and is going to have to move out of the house and give up the cars that she's been paying for. So it's not a nice process. But I'm going to change the hypothetical. So now same woman is passing away, but this time she's married and she has a child. She has a house and she also has an inheritance from a long lost uncle, Lucky. I need that type of uncle. Haven't found. So in California, I do have to explain first that our system is a bit more complex because we have community property and we have separate property. So I have a lot of married couples that come into my office and they're like, well, I really don't need a plan because, my husband gets everything if I pass away, right? I'm gonna give you a little piece of advice. When you come into my office and you say that and you have that thought process, it's like you saying, if you caught a criminal case, you'd be okay defending yourself in pro per by yourself. You don't need an attorney. You got this. You know the rules. You've obviously read in the estate planning case, you've read the probate code. You know exactly what's going on. You don't do it to yourself. Because yes, that's true that the husband, and I'm giving you part of the answer, is going to get the community property, 100% of the community property if you don't have a will or a trust stating otherwise. But that inheritance, remember I told you she had an inheritance from that long lost uncle, that is separate property. And if she didn't make that community property in some way, that doesn't automatically 100% go to your spouse. Who does it go to? Let's use our chart. So I told you she's married and she has a kid. So the correct answer is she's actually, the separate property, the inheritance, is actually going to be split by the number of children you have and your husband. So your husband gets 50% of the separate property of the inheritance, and your children get to split the other 50%. If you don't have children, what happens then? You still have a husband, but you have this separate property. Then what? Anybody niece? So if you don't have children, you have separate property, you pass away without a will, and you have a spouse, then the spouse has to split the separate property with your parents. Can you believe it? Yes. A lot of people don't know that. A lot of people don't expect that. Yeah, they're not going to get everything when it comes to your separate property. Sorry, y'all. I just got my reminder. I've been on social media too long. Y'all know I only give myself an hour here. So I hope it didn't interrupt the video. So married couples, please pay attention to that. If you have something that you received before you got married, if you have an inheritance that you got while you were married, anything that is separate property, you need to have a plan for that. If you want your husband to receive that or a spouse to receive that, then you need to have a plan. Otherwise, they're going to have to deal with your children or your parents or your siblings because they will have an ownership interest in it in California. So what else? What happens if there's no surviving person who gets the property? So it's really hard to have nobody in your family left, like you are the last of the Mohicans, but it does happen. If you don't estate plan, who gets your money then? I'm gonna give y'all time to try and answer the question. If there is nobody else in your family, who gets your money? Correct answer. It cheats to the state. What does that mean? For my clients, it means the state of California. Well, I shouldn't say my clients, because my clients got their estate plan. For people who are not doing their estate plan, it means the state of California gets your money. Like, they become the people, the entity, the government inherits your money. I mean, even if you have nobody left in your family, you still could have left it to charity. You could have created your own foundation. You'd be surprised what $10,000 could grow to in a matter of years. Look, we got some right answers. I'm clapping. I see you in the comments. Y'all warming my hearts. Y'all know the state. Y'all really want the state to have your money? No. Please don't do it. No. No. Just no. What we're not doing is no. We're not. So when it comes to not having a will, this is essentially what it means. It means, of course, you don't have an estate plan, which can have wider ramifications. You heard, if you were here at the beginning, where the lady who passed away, her family didn't know whether they should pull the plug. They didn't know what kind of care she wanted. They were trying to grieve and trying to make the best decisions for her instead of having and knowing exactly what she wanted. It means there's no tax planning. So for some people, their states have estate tax. The federal government has an estate tax, but right now you have to be over $1.4 million to hit that. That is likely to change with the new administration because that is much higher than it usually and has been. At one point, it was $1 million. At one point, it was lower than that. So tax changes are a reason why you really do need to estate plan because it shifts, it modifies, and I'm not giving up 40% of my money. I'm just not. That's not the goal. It also means, if you don't have a will, that there's no one named to act. So the government decides who's in charge versus you knowing, okay, maybe my brother isn't the best with money in general. So maybe he doesn't need to be in charge of my estate. Government don't know that. They don't care. He petitioned. Okay, he looks fit. He'll be all right. It also means you get no creditor protection. So a lot of times creditors are given notice in probate court that you passed away and that there may be assets that you left. In that case, in the case we were using, she had a house. So they could potentially get their hands on some of the assets to pay down her debts versus, credit cards are unsecured. So they're taking a risk that they may never get paid. Well, if you leave assets in probate, they could potentially get paid. They get paid before the family most times. So don't do it. And I mean, not having a will definitely means that your family has to deal with probate and no privacy. And it's heck on wheels. I don't know how to tell you how bad probate is, but if you talk to somebody who has had to go through it, I've never heard anything good said about it. I've heard that it's a long, drawn-out process. And when I actually helped with the litigation side of probate, I saw beneficiaries who had been in probate litigation for 20 years and no stop to the fighting. And the only people winning are the court, because they're getting fees, the attorneys, because they're getting statutory fees and asking for additional amounts. So, yeah, it's not a good place. So I say all that to say that There are 17 states that charge estate taxes, and that's a good reason to do your estate plan. There are a number of reasons why. Even something simple, like I'm going through and redoing my estate plan, but the way that my life and my trust is set up, I want to make sure that I have my plan in while I'm in this period of trying to comply with the state statute for my will needs 2 disinterested witnesses. Now in COVID, I'm normally at the house. I'm gonna be leaving. So I gotta find people that I'm not giving something to in my will. And while I do that, I don't want to die without a will, because what you're not about to hear is Jalen preached all of this, having your estate plan ready, and then died without one. Nah, so this is legit. My will, it's called a holographic will. You can, as long as it's in my handwriting, I signed, I dated it, and all the provisions are there, that's my will until I revoke it with the one I'm actually working on to update. So there are things that you can do. You gotta have a plan. This is a modified version of my plan, a simplified version. So worst case scenario, I'm just trying to make sure that who I want to get my assets, who I want to be in control, it's specified. So if you hear my family saying she ain't had a will, you tell them you check that house. It's on a piece of paper. Show them this Money Monday episode. Show them it's there. But I promise y'all, I'm going to get my actual drafted nice plan done. I'm going to stop procrastinating and get it updated. It's hard to update it. It's a lot of editing. So let's jump back. And if you have any questions about estate planning in California, I wrote a whole book on it. It's called Controlling Your Legacy. It's on my website. It's on Amazon. It just breaks down all of these concepts, all of these terms. Use it kind of like a manual to understand. But I've also used famous stories and help you understand what each document does in your estate plan. And I talk about intestate succession, dying without a will. So let's go back. I'm gonna run back and see if we had any more questions in the chat before I let y'all go. But thank y'all for coming before. Okay, so okay. So we have someone who has a divorced mom, and she lost the divorce papers in a move. Luckily, they're public record. They're at the court, so you can always get a copy of them. Will a will help her determine what happens Will a will help her determine what happens? So 2 different issues there. I definitely want you to get a copy of the divorce decree so that you know, because sometimes they talk about the assets that you have. A lot of times in California, spouses are allowed to, they're given, not given, community property, anything that you acquire while you're married is 50-50. So that goes with retirement accounts. While you're saving your retirement, 50% of that is your spouse's. So a lot of times divorce decrees, they'll decide, is 50% of that yours or another agreement to the contrary. So it might help her understand what her full assets are after the divorce. But a will is definitely going to help her decide and make her decisions about what she wants to happen and who she wants to be in control, and kind of, help her with her plan. Now, depending on the assets that she has, she may want a trust to avoid probate entirely. But if she has a smaller estate, like in California, if you're under $166,000, you can do a small estate affidavit, which is like a super, super modified probate. And you don't have to go through the full process. So it depends on what she wants and what her assets are, but it's always good to have a full estate plan. And by that, I tell y'all all the time, just having a trust is not enough. Just having a will is not enough. Just having an advance directive is not enough, or a financial power of attorney is not enough. Those documents are meant to work in conjunction and stop and handle all the problems that you could potentially face. So estate planning is planning for the worst, thinking of all the scenarios and then the worst of everything and having a plan for it, so that when that worst happens, you're ready. You're like, wait, I got a plan for that. I know where I am. So I hope that answers your question. Oh, good. You said the chart helped. Maybe I will try and post that later for you guys. How do you feel about plans when you prepare for your funeral? So a lot of people plan their funeral in their advance directive. They can do it in your will. You can do whatever you want in your documents, depending on who's drafting them and how flexible they are. Like the form wills, like the legal Zooms, it's harder to change their documents, but most people decide. I've had a lot of clients that are like, I want to be sent to this science center so that they can learn more about the human body. I want to donate my body to science. Some people are like adamant, I do not want a funeral. This is a celebration of life. But they're able to put that in their documents so that the people that they're leaving in charge know. And that's what it's really about. Letting people know. Look, we celebrating. Y'all all gonna wear white. We not about to be sad. We gonna party to Kendrick Lamar. We're gonna be all right. Like, you can do that. You can specify that this is how the end of my life should be governed and celebrated. You can tell them where you want to be buried. If you want to be buried, you have control. I mean, otherwise you're at the mercy of people, doing what's traditional. And that may not be what you want. And we about getting what we want. We working too hard. All right. Can we hire you for estate planning if we're in another state? No, ma'am. I know. You can work with me, and I can try and help you prepare to meet with another attorney. So giving you tips on what to ask based on what you're trying to accomplish, and interviewing. But now, if you're not in Cali, at this point, I don't want to take another bar exam. So I'm going to stay here, nor pay for another license, because these license fees are not cheap. So I stick here. I'm sorry. But I am trying to build a network of other attorneys that are focused on you and your best interests like I am. So I am meeting new attorneys every day. I am interviewing them for you and then teaching you how to interview them. So hang in there with me, and you can always ask me if I know somebody in your state. I also, in the comments on one of my posts, was telling people about Justice Connection, which is on the East Coast and specializes in helping us find POC and Black attorneys licensed on the East Coast. So, and I know the founder, she is amazing, an amazing Black woman. So check them out if you are on the East Coast. But no, I can help you if you're in California. Financially, I can help you if you're anywhere in the world, but I specialize in, California, because California is a different financial beast, and everything that you hear on social media doesn't normally apply to our city, our state. So, is estate planning state specific? Yes. Every state is different. I'll tell you that in California, you have to be 18 to estate plan. That's the age. Where in Georgia, I think it's 14. They allow you to start estate planning at like 14. It's whatever your state and your probate code allows. So Yes, it is state specific. So make sure you get somebody licensed in your state, because it's really about them understanding your state laws. And if you want to take a look at the probate court code, please do. So that you know what to expect. All right. I think we worked through all of these questions. I'm so excited that you guys want to know about intestate succession, and hopefully you'll be avoiding intestate succession. I know. I appreciate you guys for coming. It is hard to type in this little box, but that's why I make sure at the end that we take our time, so you don't have to rush. And then I'm around social media all day on Mondays to answer any other questions. So if you don't get your questions answered here, type them in the last post or under this. I put this up for a replay, so I want you guys to get the information. Oh yeah, you're right, Octavia. They do have pay for your funeral now planning. I have seen a lot of insurance companies that do that. I'm gonna be quiet. I'm gonna be quiet. I know I looked at my grandma's policy and I was like, you pay what? For what? So pay attention to them. Understand what you're really getting, please. I do love the people that are buying their crypts and their plots. At some point, my aunt went crazy with that. She was out buying them out of the penny saver and like flipping them. I was like, really? You darn hustler. But it's just like real estate. The prices go up. And it's something a lot of us don't want to think about. So she was coming up. Okay, we got a question. If I specify a beneficiary in my investment accounts, can that be contested after my death? Most of the time, it's really hard to contest a beneficiary designation because a lot of people don't find out about it. The insurance company makes you provide a death certificate. They really don't tell you or notify anybody else that you've been named. But if you give them the death certificate and you happen to be the person on the policy, then they give you the money. So, and it's also not an asset that goes to probate unless the people that you appoint are not around, i.e. they passed away before you and you didn't update, or the people that you appoint don't accept the money. It happens. Some people are like, I don't want to take that tax hit. So, for the most part, you don't see a lot of people that are contesting the beneficiary designations, unless it's like an ex-spouse, like you didn't update your documents after you got divorced, and maybe your decree doesn't talk about it. Some families decide to fight that. I appreciate you guys for coming. I don't think I see any more questions in this little box. So I want to make sure, I'm going to give it like 2 more minutes, but I appreciate you guys all for coming. I do want you to understand that it's not as hard as it seems to just start thinking about this, especially if you have no kids, especially if you're single. I want you guys to make sure, because you're normally the people that build the most wealth. I want you guys to make sure that you are doing your documents, because as you see, people are leaving $800 million to the state to deal with, to figure out. That is going to be nuts. I'm not going to go there because we're going to think positive. You guys are all here because you want to do your documents. So if you need any help, have any questions, feel free to ask them. I appreciate y'all, and I will see y'all next week for another Money Monday. If you have any topics you want to discuss, let me know. We are on estate planning all month, but you know, I've been known to throw in some other stuff in there. So thank y'all. I will see y'all next week. Bye.